Ladies and gentlemen, what if I told you that in the United States of America today, the government can take your home, your life savings, your car, your bank account, even your business, without charging you a single crime? No arrest, no discovery, no trial, no conviction. Just a knock on the door or no notice at all, and it's gone. No longer yours. This isn't fiction. It's civil asset forfeiture, and it's happening every day in our country. Under this system, the government can seize your property not because you committed a crime, but because they claim it might be connected to anyone. You don't have to be charged, tried, convicted, or even heard in some cases. And once your property is taken, you must prove your own innocence to get it back. How do we get here? Civil forfeitures date back to the 17th century English maritime law, when the crown could seize vessels tied to piracy. But in 1984, in the name of fighting drugs, the U.S. Congress rewrote the rules with the Comprehensive Crime Control Act, giving police a powerful new incentive. They could keep whatever they took. And that opened the door to corruption in local municipal police departments, all the way up to our once esteemed federal agencies. What was once a narrowly defined tool to disrupt criminal networks mutated into something far more dangerous: legalized theft without due process. Let me show you what that means in practice. In Philadelphia, Markella and Chris Sorovelis owned a modest family home. One day, police knocked on their door, not to arrest them, but to evict them from their home and take possession of it. Why? Because their son, without their knowledge, was accused of selling $40 worth of heroin. That's right, $40. The police seized their house, screwed the doors shut, and had the electric company cut power on the spot. They were never charged with a crime. They never even got a hearing before their home was seized. But their property helped fund the Philadelphia District Attorney's Office, an office that, at the time, got 20% of its budget from forfeitures. Let that sink in. 20% of the budget of the District Attorney's Office in a major American city came from civil asset forfeitures from the people that very office was created to protect. Or consider Lisa Leonard. Her son was pulled over for speeding in Texas. In the car was a safe holding $201,000 in cash, which were proceeds from the recent sale of her house. No drugs, no weapons, no crime. A police officer simply wrote, quote, "In my experience, large amounts of cash are associated with narcotics," close quote. And that was all it took. Her money was seized on the spot. No charges were ever filed. Lisa went to court, all the way to the Supreme Court, and lost. She lost everything. Finally, take the case of Crystal Starling, a nursing assistant in Rochester. Police raided her apartment in 2020 because they suspect her boyfriend of wrongdoing. They found $8,040, her hard-earned savings, and they seized it. Crystal was never charged. Her boyfriend was acquitted, but the DEA kept the money. She tried to fight back, but missed a court filing deadline and lost everything permanently. This is how civil forfeiture works. Your property is declared guilty of participating somehow in a crime and seized. You bear the costs to prove otherwise, and all the while, the same police and prosecutors who seized it profit directly from what they take. These aren't isolated incidents. As I said, this goes on every day. In 2018 alone, state and federal agencies took over $3 billion in property. And because many small seizures go unreported, the real total might be very much higher. The median amount seized is just $1,276, far less than the cost of hiring a lawyer to fight it. In many places, police use forfeitures to buy surveillance equipment, submachine guns, even luxury vehicles. All of this under a practice that bypasses constitutional safeguards. No presumption of innocence, no right to counsel, and often no judge nor jury involved at all. Nobody should have to fight this hard just to keep what's theirs. We must ensure that our laws protect the innocent and uphold the principles of justice that are the bedrock of our society. We're here today to shine a light on a system that tramples the Constitution, targets the innocent, and enriches the very people empowered to uphold justice and protect us. You're going to learn about two cases where the abuses were even more severe and costs far, far higher. You will see how the law was manipulated, not to stop a crime, but to take what many good people had honestly built for themselves over decades. Tens of millions of dollars were simply taken away. Homes, offices, businesses, apartments, and precious metals were seized. College educations had to be abandoned. Hopes were crushed. Weddings canceled. Marriages broken. People hospitalized. And an innocent man was sentenced to 23 years in federal prison for a crime he didn't commit. Now you may wonder how all this is possible in America today. You're about to see. The facts will disturb you. Learning about them may make you fear that such a thing might happen to you or someone you love. But the facts will also empower you, because justice here begins when people like you say, enough is enough. It's time to address the abuses of civil asset forfeiture and restore the balance between law enforcement and the rights of the people. In our country, you have the power to do that. So together, we will place civil asset forfeiture on trial, not in a shadowy courtroom run by prosecutors, but out here in the open for all to see. Because where the government doesn't need to prove guilt before taking what's yours, no one is truly free. This isn't like the usual opening statement that an attorney would give to introduce a case to a jury. No. This is more like an expose. You're going to uncover facts about cases that have already been partially adjudicated improperly. In one, a summary judgment was granted for the government's benefit. But a summary judgment requires that there be no material facts in dispute between the parties, and there were many. That case is now on appeal, waiting for a decision. In the other, a man we believe is innocent was convicted on baseless charges and sentenced to 23 years in a federal prison. You'll soon see why we believe the charges were baseless and the man innocent. Let's start at the same time and place where the victims were first made aware that the government had an interest in taking their property. At 7 o'clock in the morning on Thursday, April 18th, 2019, on a peaceful street in sunny Lakewood, Florida, Oasis co-founder and CEO Michael DaCorta, his wife Carolyn, and daughter Crystal were rudely called out of bed by someone banging with deafening urgency on their front door. Still in his underwear, Michael went downstairs, opened the door, and was immediately confronted by people incomprehensibly screaming at him. Nearly a dozen government agents and local law enforcement stood in his yard pointing weapons at him. He was told that the FBI had come to serve an IRS search warrant. At no time that morning was he given a copy of that search warrant, as agents swarmed throughout his home, seizing and boxing household items and taking photographs. He wasn't shown any official identification, and he wasn't free to leave. For more than 5 hours, his wife and daughter were confined under careful watch in the living room while he was interrogated without a lawyer present in a closed room. He was never informed of his rights. He was not free to ask questions and didn't understand why this was happening. Believing that his partner, his business partner and company attorney, Joe Annealy, would later clear the matter up and confident that he had done nothing wrong, Michael readily answered the agent's questions. Interrogation by an FBI and an IRS agent was followed with more of them by an attorney from the Commodity Futures Trading Commission, the CFTC, a investigator, and Mr. Burton Wind, the temporarily assigned receiver for the case. Mr. Wind told Michael that morning that he now owned all the property that had once belonged to Michael's companies, Oasis Management and Oasis International Group. Shortly after noon, with boxes of household items loaded into the cars, Michael's cell phone and the family's car keys seized, everyone left. On their way out, the CFTC attorney dumped a 12-inch pile of papers on the pool table and informed Michael that a hearing was scheduled for April 29th, but that if he signed a consent agreement, it could be rescheduled. He had no idea what was going on or why. That same day, Oasis's office and all its company-owned land, homes, and apartments were seized. The following day, Michael learned that the raiders had confiscated his personal bank accounts and those of his company. They controlled Oasis's email account and had all mail rerouted to Mr. Wiehen's office, including mail for his children's bank account. His cell phone containing all his contact information wasn't returned for a week. From the morning of the 18th, Mr. DaCorta had no bank account, no job, no car, and no funds sufficient to hire an attorney. They had left him with no resources to protect his rights. Due process was systematically denied, all on the basis of an accusation based on uncertified research done by a CFTC investigator that had been filed in court a couple days earlier. So let's back up a couple days to see what happened before the DaCortas were so indecently awakened on the morning of April 18th. 3 days earlier, the CFTC filed a civil complaint in the Middle District Court of Florida in Tampa, charging Oasis with 5 counts stemming from violation of the Commodity Exchange Act and Commission regulations. All of the counts allege that through the operation of the commodity pool, Oasis violated the act by not complying with CFTC rules and regulations. The complaint also alleged that Oasis operated as a Ponzi scheme. The CFTC's burden of proof in civil trial is to show by a preponderance of the evidence that the Oasis defendants were guilty as charged, but the CFTC managed to skip over having to meet that burden by getting the judge to grant them a summary judgment, which dodged a jury trial and closed the case. At the time this statement was first made public, that case awaited a ruling from the 11th Circuit Court of Appeals. Oasis's argument on appeal points out that by law, in order for there to be a commodity pool, investor money must be used, but under terms of the promissory note and agreement by which Oasis money was obtained, there were no investors. The funds came only from lenders who, by contract, agreed to retain no interest in them. You'll see that by law, a Ponzi operation must be insolvent from its beginning, but Oasis's balance sheet shows that Oasis was never insolvent, ever. But unfortunately, the balance sheet wasn't available until December of 2023, more than a year and a half after Michael DaCorta had been convicted and sent to prison, because no one before that had created it. Neither the CFTC nor any other agency of the government ever presented a certified balance sheet. Doing so would disprove their allegations of Ponzi-like operations and require a reconsideration of Mr. DaCorta's conviction. Had it been filed from the start, it would have prevented Mr. Wind from opening a clawback case against about 100 lenders and causing even more distress, property seizures, and the loss of more innocent lender money. The day after the CFTC's filing and the day before anyone in Oasis was alerted, a civil asset forfeiture case was opened against the 8 properties owned by Oasis. The asset forfeiture case was presided over by Judge William F. Jung, who later presided at Mr. DaCorta's criminal trial. The plaintiff, being the government, was represented by U.S. Assistant Attorney Rochelle DeVoe-Bedke, who later became the chief prosecutor at that criminal trial. 8 company-owned properties were, quote-unquote, represented by attorney Jared J. Perez, who worked for and also represented the receiver, Burton Wind. 3 years later, Mr. Wind showed up as a witness against Mr. DaCorta at his criminal trial. Since all his money had been seized, Michael was unable to pay for legal assistance in either case. It later turned out that Oasis co-partner and universally presumed corporate attorney Joseph Annealy, whom Michael depended on for both personal and corporate legal advice, had begun stealing funds from Oasis almost immediately after he took authority over its financial transactions. The records show that he embezzled nearly $3 million from the company, for which he was never charged. On August 9th, 2019, Mr. Annealy was charged with the same 3 counts that Mr. DaCorta was charged with the following December. He waived indictment and 3 days later signed a plea agreement by which he was later convicted of criminal charges and agreed to be a prosecution witness at Michael DaCorta's criminal trial. After several time extensions, on November 24th, 2020, Mr. Annealy was sentenced to serve 10 years in prison. By virtue of a motion signed by AUSA Rochelle Bedke, he remained free at home under supervision until the date of Michael's criminal trial. After the trial, Ms. Bedke filed another motion, supported by a letter from Mr. Wind, that resulted in Mr. Annealy's sentence being reduced to time served, which by then amounted to a few months in a hospital prison where he could be treated for chronic heart issues before being released a free man. Michael's criminal trial began on the 3rd anniversary of the raid, April 18th, 2022. He was charged with 2 counts of fraud against the lenders and 1 count of filing a false income tax return, and convicted on all 3 counts by a jury of 12. He was sentenced to 23 years in a federal penitentiary where he was, at the time this statement was first made public, still serving time. As the evidence will make clear, Michael DaCorta was convicted on the first two counts because attorneys on both sides misrepresented or altogether failed to present evidence that may have given the jury reason to acquit him. Hereafter, we present the neglected evidence and misrepresentations for your consideration. At the center of both the civil and criminal cases is a contract, a promissory note and loan agreement signed by every lender. It wasn't vague. It wasn't buried in fine print. It was clear. Oasis would borrow money. Lenders would earn either a 12% annual return or a percentage of Oasis's spread fee earnings, whichever was greater. It promised no ownership, no equity, no claim on profits, nor harm from losses, just a loan. Not vague, not hard to understand. It was signed, dated, and written in plain English, and Oasis honored its terms month after month until federal agents stepped in and seized everything. The government argued that Oasis promised something else, that lenders were deceived into investing in a fraudulent scheme. But the evidence shows there was no investment, just a loan. The contract said so. The risk disclosures said so. In the videos, you'll see literary and legal examples from the Merchant of Venice to Apple's licensing deal with Microsoft, showing how misunderstanding a contract can destroy lives and fortunes. And you'll see how, in this case, prosecutors didn't just misunderstand the contract, they misconstrued it to the hapless lenders and to the jury. The government redefined the lenders as investors. It redefined a loan as a share interest. It pretended that Oasis lenders had been deceived because Mr. DaCorta had not disclosed the consequences of bad trading, but the agreement held no requirement for him to do so. He lost the company's money, not the lenders. And the government convinced a jury to convict the man based on words never written and terms never promised. Michael was convicted for not doing something he had no obligation to do. The evidence shows this case did not begin with a fraud perpetrated by Michael DaCorta or his company. It began in allegations and misrepresentations designed to serve the government's own ends, not justice for the lenders. It ended in distortion, deceit, and calumny, which is a false accusation of a crime maliciously made to the injury of another. Most importantly, a conviction was reached because of an utter failure to defend the defendant. The evidence shows that the government did not prove fraud, and I believe you'll agree. The government didn't prove Michael's guilt beyond any reasonable doubt, which was its burden. Instead, it ignored the actual contracts and convinced the jury that Oasis was running a Ponzi scheme. By mischaracterizing a lawful debt instrument as a fraudulent scheme, prosecutors reversed the clear meaning of the contract. Ladies and gentlemen, the only fraud was the one perpetrated by government agents. In the civil case, the government argued that Oasis operated a commodity pool, that Michael DaCorta had defrauded investors, and that lenders were victims of a sophisticated financial crime. But the evidence shows that none of that is true. As you will see, the case hinged not on fraud, but on something else entirely: jurisdiction, ownership, and authority. Oasis legally owned its own broker-dealer. It wasn't acting as a third-party manager. It wasn't soliciting investors for a fund. It was trading for itself, with its own money, in its own name, legally beyond the authority of CFTC regulations. There were no investors. There were only lenders, and each one had signed an agreement. Each agreed that they would not share in profits or losses. The loan money did not constitute a commodity pool. Oasis didn't promise lenders ownership, and Oasis was not their fiduciary. The only way civil and criminal actions could proceed was to sustain the fiction that lenders were investors, so the government agents did just that. The very legal foundation of both the civil action and the criminal prosecution rests entirely on a falsehood, which was the misrepresentation that lenders retained an ownership interest in funds that they had already surrendered under contract. The contract language clearly shows Oasis could use funds for any purpose and commingle, pledge, assign, or rehypothecate them, and that Oasis was under no fiduciary obligation to lenders and had no duty to report the use of loaned funds. The evidence shows that once those funds were loaned, they became the lawful property of Oasis, free of any claim, right, or control by the lender. Case law supports it. The agreements confirm it. And yet, the government skipped right past the contracts, ignored the jurisdictional requirements, and filed suit under the Commodity Exchange Act anyway, claiming Oasis should have been registered as a pool operator. But registration only applies when a company trades on behalf of clients. Oasis didn't. Regulators never issued a cease and desist order. There was no hearing, No certified accounting, no ruling, no final agency order. Instead, government attorneys convinced a judge to freeze assets before trial using a statute that required proof of customer funds, which didn't exist. Then they used the asset freeze to create the desired end goal. The end goal was to deprive Oasis of its ability to continue operations, fund a defense, or make its case, and surrender its assets to them. You'll also hear about the receiver, a man appointed by the same court that authorized the seizure. As a trial witness in the criminal case, he testified that his job was to protect the assets, but evidence clearly shows that he spent years liquidating them prematurely and therefore below market value, all while billing the estate millions. And most disturbing of all, the same misapplication of law that enabled the seizure was used to justify a criminal prosecution. A civil violation became a criminal charge, and an unproven theory of registration failure became the foundation for a 23-year prison sentence. The evidence you will see shows that this case was built on a fiction, that Oasis owed a duty it never legally did. When the government takes your property, your livelihood, and your freedom under such pretext, it's not law enforcement. It's a forfeiture by fabrication. Ladies and gentlemen, the fraud wasn't in the business. It was in the courtroom. The government constructed a tale of magic money and financial illusion, not because it was true, but because the real numbers didn't support their case. Oasis earned spread fees through its own Forex broker-dealer. Every time a trade was entered, a transaction fee was charged. Just like a movie ticket lets you into a theater, a spread fee lets you enter a trade. The outcome, win or lose, has no bearing on the fee itself. Oasis earned over $51 million in these fees. The amounts were real, recorded, and verified by third-party systems, and a very highly qualified certified public accountant. But the government represented to the jury that they were, quote, fairy dust, fictional, an accounting trick. And Michael's defense counsel chose not to bring their own well-prepared trading expert to the stand to set the record straight. And the contract, the promissory note, under certain conditions, gave lenders the right to share in these fees, but never promised them anything from the actual trade results themselves. So when the government claimed that Michael DaCorta defrauded lenders by hiding trading losses, they ignored a crucial legal fact. Neither he nor anyone at Oasis had a duty to disclose trading results. Once the money was loaned, it became the sole property of Oasis. It was free by contract and by law to do as it saw fit with the funds. The government mischaracterized the entire arrangement. It forcefully and repeatedly mischaracterized legitimate fees as an illusion and used that illusion to paint an honest man as a fraudster. The fraud wasn't in the business. It was in the courtroom. This wasn't a fairy dust fable. It was accounting. It was contracts. It was math. But it was ignored, and a man's life was consigned to a federal prison for 23 years as a result. Ladies and gentlemen, the Constitution guarantees us a fair trial, which means the government must prove its case with evidence, not emotion. And it means the jury must base its verdict on the facts presented, not what's implied, assumed, or repeated until it feels true. Certainly not a fictionalized misrepresentation. In this case, the jury never saw the evidence that mattered most. Instead, they were bombarded with repetition, distortion, and emotionally charged language. The word Ponzi was heard 94 times by the jury. The word investor 311 times. No one objected. No one corrected the record. These weren't just rhetorical flourishes. They were substitutions. Substitutions for the real legal terms, for what the contracts actually said. There were no investors, there was no commodity pool, and the promissory note agreement clearly defined the relationship as one of a borrower and lender, nothing more. But the jury didn't hear about those documents. They didn't see the promissory notes. They didn't see the loan agreements, the risk disclosures, the internal balance sheets, or the spread fee calculations, certainly not in detail. And the defense didn't bring in expert witnesses to explain any of it. Instead, what the jury saw were people who felt betrayed, witnesses who were emotionally shaken, some of whom had ignored the very agreements that they had signed. And the government presented that emotion, as if it were evidence. Perhaps most strikingly, the jury never saw the complete financial picture. The company balance sheet showed Oasis had over $55 million in assets, but it had either never been created or was kept out of sight. This was not an oversight. It was a strategy. Keep the jury focused on feelings, on language, on carefully selected fragments, and hide the rest. This is not how justice works. The government, inadvertently aided by the defendant's own counsel, secured a conviction by controlling what the jury could see and what it could not. This is not due process. This is not fairness. This is not law. This is theater, and it has no place in a courtroom of the United States of America. Restitution for all of this is called for. Thank you.